Assalamu alaikum wa rahmatullahi wa barakatuh. Bismillahir Rahmanir Rahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala Nabiyil Ameen wa ala alihi wa sahbihi ajma'in wa tabi'ina lahum bi ihsanin ila yawmiddin. Distinguished guests, my brothers and sisters, ladies and gentlemen, welcome back to our weekly lecture. And today's lecture entitled Legal and Sharia Framework of Contemporary Islamic Finance and Disputes Resolutions Mechanism. And the lecture will be conducted by Associate Professor Dr. Muhammad Zakhiri bin Muhammad Noor from Malaysia. So this is a part of our activities and events, lectures, organized by Nadil Iqtisad al-Islami, Islamic Economics Association of Kuwait University, to promote Sharia compliant models, strategies, policies, and our activities and programs usually highlight Islamic banking, Islamic microfinance, insurance, capital market, equity market, and also some of the specific topics, including sukuk, retail, corporate banking products, fintech, wealth and debt management, and some other contemporary issues. So we are very much honored today to have our Associate Professor, Dr. Muhammad Zakhiri, who is the Deputy Dean at the School of Law, University Utara, Malaysia. He was appointed to the IAC Arbitrations Rules 2022 Revision Committee of the Asian International Arbitration Center. He was also a CEU Faculty Fellow and a flagship program under the Ministry of Education, Malaysia. He is also an associate member of the Association of Sharia Advisors in Islamic Finance, Malaysia, member of Chartered Institute of Islamic Finance Professional, a research fellow in Institute of Excellence in Islamic Jerusalem Studies, and a research fellow at the Institute of Management and Business Research, and fellow at Sharia and Business Law Research Unit of University Utara, Malaysia. And Prof. Zakhiri is also an Islamic finance consultant to a few legal firms, an editorial board for reputable journals, a trainer in the area of Islamic finance and Sharia committee members to Islamic financial institutions. His research area includes Islamic banking and finance law, Islamic capital market, takaful, Islamic financial technology laws, and Sharia studies. Dr. Zakhiri holds a PhD in Islamic finance from INSIF University. And earlier, he graduated from the International Islamic University, Malaysia, reading LLB in Bachelor and also LLB in Sharia, and Masters of Comparative Laws, and Chartered Islamic Finance Professionals from INSIF University, and Islamic Financial Planner from IBFIM. And Prof. Zakhiri is also a Sharia Council of the Federal Territory of Kuala Lumpur and was admitted to the Malaysian Bar in 2005. So this is indeed an honor for us to have Associate Professor Dr. Muhammad Zakhiri to conduct today's lecture on legal and Sharia framework of contemporary Islamic finance and disputes resolutions mechanism. So please welcome, Prof.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much to Mr. Chairperson, Dr. Muhyiddin. Thank you very much as well to Kuwait University and the Association of Islamic Economics, Kuwait University, and professors, lecturers, students, and all the participants who attended this event today. And in fact, this is not and I'll share with you some of the information, the movement, I mean the recent development of the contemporary Islamic finance in Malaysia, Malaysia context. So I'm Muhammad Zakhiri Makno. I'm a lecturer as mentioned by Chairperson just now at the School of Law, University Utara Malaysia, Jamiah Utara di Malaysia. It's located at northern part of Malaysia, And if you have the opportunity, please welcome to University Utara Malaysia. And I'm attached at the School of Law, University Utara Malaysia. Right, let me share whatever the topic that been entrusted to me, that is legal and Shariah framework of the contemporary Islamic finance and dispute resolution in Malaysia, where I will cater the what I call the framework of the businesses, and I will touch on the legal framework within the Malaysian context. Yeah? And touch on who are the regulators, the role of the regulators, and I will also discuss on the dispute resolution mechanism as far as Islamic finance is concerned. I will touch a bit on the role of ADR as well as what I call the court in Malaysia, the attitude of the court, and how they resolve the disputes between the bank and the customers. So as far as the legal framework is concerned, you see the foundation of Islamic finance is pretty much depends on the revelation itself, and it's pretty much defend the relationship between man and man, because it's a contract. It's a contract. So if we see at the macro level, the entire process of transaction, the relationship between man and man is basically based on the framework of economy, because economy is basically a mobilization of resources. Because Allah Subhanahu wa Taala create all bounty of resources to humankind, and we do business in real transaction and whatnot, and whatnot. This is basically the entire economy, the backbone of the economy. And then because of the scarcity of the resources and whatnot, after the World War 1945, people have the scarcity of the resources, lack of the resources and whatnot. People start invent the fiat money. So finance, the theory of finance is basically the allocation of the assets and equity, whether it's pretty much depend on debt or equity. While economy is basically a mobilization of resources. Then because of the World War 1945 and whatnot, uh, we have the problems of the resources and whatnot. Previously, people do what they call barter trading and whatnot. Because of the war, things like that, we have the problems of the changings of the goods and medium of changing of the goods and services and whatnot. And people start create what they call fiat money. Fiat money. And then what is basically the role of the banking? The role of banking is working under the framework of finance. It's not working under the framework of real economy as the way it should be. So the essence of banking is basically money borrowing and lending. Money borrowing and lending with interest. But the notion of interest is not nothing new. Is also prohibited in the Christianity, and in fact, Islam also forbid the notion of interest. The banking framework is working under the umbrella of interest regime. The essence of the bank is basically money borrowing and lending with interest. And the relationship between the bank and the customer basically debtor and creditor. But what is the position of Islamic banking then? So Islamic banking, actually the contemporary Islamic finance, working under the umbrella of the conventional banking. And of course, they have what's basically governed between relationship between the parties pretty much depends on the akad. On the akad. Of course, the Islamic banking also need to follow some of the requirements dictate by the World Bank, like the compliance of Basel Committee is whatnot, the compliance with the Basel Committee, Basel 1, Basel 2, Basel 3, and the like. Well, so in the first slide, we can see here the notion of the transaction. Basically, it should be in the real economy, because where the economy is that basically mobilization of the resources between one country to another country, between man and man and things like that, because we have bounty of resources. So because of the scarcity of the resources and whatnot, and the war and things like that, people have the problems. And then people start invent the theory of finance. That is basically the allocation of assets. Allocation of the assets, whether it's debt or equity. So whether you transact with more on equity or you transact based on the notion of debt, of debt. So Islamic banking, a banking framework is basically working under the umbrella of finance, the theory of finance. The essence of the banking is basically money borrowing and lending with interest. The bank take deposit and lend it to the others, give financing and is backed with the interest. So what is the position of Islamic banking here? So the small dot here is working under the umbrella of conventional banking within the theory of finance and whatnot. It's far away from the theory, real theory of economy or Islamic economy. So in the Quran, Allah Subhanahu Wa Taala mentioned about the notion of what they call tijarah, tijarah and al-bay'. So what is the difference between a tijarah and al-bay'? So the tradings would be between one country to another countries, and Allah Subhanahu Wa Taala forbid what they call the rich, all the trading among the rich countries. Among the rich is not surplus among the poor. And Allah Subhanahu Wa Taala create the rich people and the poor peoples, the essence of what they call of the economy. As far as economy is concerned, we're talking about risk sharing. So the rich need to share with the poor. So you see about the contract that we have, like mudarabah, musyarakah, is all about risk sharing. Risk sharing, risk and profit sharing. Because if you have the money, you have the capital, the one is do on the work for you, is called it mudarabah. If two of you put the capital, we call it musyarakah. So another option is that I have a rich, I appoint you as an agent. Uh, you work as an agent for me, as a wakil. So the notion of the trading to forbid the notion of riba basically through mudarabah, through musyarakah, through wakalah. It's all about sharing, risk and profit sharing. So that's the trading should be, among should be surplus from the surplus countries to the poor countries and whatnot. So what so happen if the data you see in the OECD countries, most of the trading at the international level is lingered around the rich countries. So what will be happen to the poor countries and things like that? Sale is basically the impact between man and man, you know. So what is the effect of sale? Basically the transfer of ownership right, by the seller to the buyer. So it should be a complete transfer of ownership right. So this is basically the effect of sale. So what is the relationship, as I mentioned to you, between the bank and the client? So as far as the conventional bank is concerned, the relationship is between debtor and creditor as enshrined in the case of folly versus sale. So I'm a customer, I have the money, I go to the bank, either I open the current account, the saving account. After a certain period of time, I expect the bank give some interest to me. And the bank use our money creation, and lend our money to other people. So this talking about money borrowing and lending with interest. So what is Islamic banking? It's pretty much the relationship between the bank and the customer is depends on the notion of the contract, be it wadi'ah contract, be it mudarabah or musyarakah, be it tawaru, murabaha, and the like, or ijara, and the like. So Islamic bank relationship is between the pretty much depends on the akad itself. So if anything, we need to see what is basically how Islamic principle being used on all in those akad. So we are fortunate in Malaysia. Central Bank of Malaysia pass what call all the parameters. We call it Mi'yar Syar'i Limuntajat Al-Islamiyah. We have, I think, 11 or 14 parameters, be murabah, tawaru, ijara, and like that. And everything is accessible through Bank Negara website. So at macro level, we see who's basically control the economy, control the who is the main regulators. We have the World Bank, we have what I call IMF, we have International Monetary Fund, we have Basel Committee and Supervision, we have International Center for Settlement and Investment Dispute, and Bank of International Settlements. So they basically dictate the notion of the what I call banking system by the World Bank, IMF, things like that. So Islamic bank need to follow all the requirements set up by the World Bank, by the World Bank, and then what is basically the role of the OIC countries, the world of Islamic bank. So how Islamic bank really, spur the growth of the what they call the notion of real economy, the notion of Islamic inclusions, for that matter. So perhaps further study need to be made. What is basically the role of the Islamic banks, to in that matters, to spur the growth of Islamic inclusions, so that all the wealth, the creation of the wealth can be shared to all spectrums of the societies in the world. Right. Can we move to another slide? So this one I already mentioned as well. Can you move to another slide? This one also that finish. The next slide. This one also I already mentioned just now. So now we look into the framework of Malaysia. So Malaysia is very unique because before the comings of the British and whatnot, Islamic law used to be the law of land in Malaysia. We don't have what they call, we have what they call the institution of Baitumal, we have the institution of Wakaf and things like that. And so when the British coming into our land, so they changed what they call the law, the legal framework that we have. Because previously, when the entire under the Malacca Sultanate, Islamic law used to be the law of the land in this country. And in Malaysia, we have 14 states, very beautiful states. And these states have what they call Undang-Undang Tubuh Negeri. And in the Undang-Undang Tubuh Negeri, mention about the notion of what they call hudud, takzir, and the matters pertaining to muamalat. So after the coming of British, so British what they call rule us through what they call federal constitutions. Well, federal constitutions, and his entire control the what I call the legal system that we have, the law that we implemented, and whatnot. So this is there are matters under the federal level, there are matters under state levels. At the federal level, including what I call banking matters, banking and finance, while all Islamic matters are under the purview of the states. Meaning, it's not what I call the become the law of the land. It's become the state's matters pertaining to Muslims, pertaining to Muslim, particularly Islamic law matters, Islamic family law matters. So in Malaysia, as far as Islamic banking is concerned, Bank Negara run world banking system. Well, we have conventional as well Islamic banking system, and it's run parallel. It's run parallel. It run parallel together. Janban bin janbin. Jarian ni bain bank taklidi wa bank al-Islami. So how we start the Islamic bank? We start with what we call the notion of what we call bank Islam, and then we have bank muamalat, specific bank, and then we start before we convert all the conventional bank to the another Islamic banking entity. We start with very small, with window banking, window banking, and in Malaysia, the establish of bank is very unique. They are cater the bank for specific purpose. We have what they call retail banking, corporate banking. We have the bank for all the what they call the agriculture sectors. Like we have bank agro bank, bank Azirai in Malaysia, agro bank, and then we have the bank that caters for import and export trading businesses. We established the bank for infrastructures. So there are funds that most we have banks simpanan nationals. There are some of the bank where the capital mostly been injected resources from the government, and there are bank the source of the capitals based on the deposits and shareholders' monies and whatnot. So in Malaysia, we have what they call foreign bank as well that operate in Malaysia. They start with ICBU, running Islamic banking business. Can we move to the next slide, Shariah? And then who are the regulators as far as Islamic banking is concerned? So Bank Negara, we pass the specific law. We have specific law, Qanun al-Khas yang yadur oleh Masarif Islamiyah. We have IFSA, Islamic Financial Services Act 2013. So it caters Islamic banking business and takaful business in Malaysia, right? But we're talking about Islamic finance just now. We're talking about capital market. We have separate regulator. We have Securities Commission of Malaysia. Securities Commission of Malaysia. And then we have Bursa Malaysia. And then we have what we call Labuan. Labuan. So Labuan also report offshore banking. They also have the implement Sharia principle. They have the Sharia advisors to cater to ensure the entire operation is basically Sharia compliant. So in the nutshell, what we can say, as far as Islamic finance and banking in Malaysia is concerned, we have four regulators here. We have Bank Negara Malaysia, Central Bank of Malaysia. We have Securities Commission of Malaysia that cater what we call Islamic equities and market. We have Bursa Malaysia. We have Labuan. So in all these regulators, they have what they call Sharia Advisory Councils. Sharia Advisory Councils that ensuring the entire businesses, muamalat matters are basically in Sharia compliance. Sharia compliance. So in Islamic in Central Bank of Malaysia, we have what call Islamic banking in Malaysia just now before the slide. Any before that you remain to the slide before this one. We still this one on this one. So Bank Negara Malaysia cater for Islamic banking business as well as takaful business. So what is basically the law that cater all this business is Islamic banking, Islamic Finance Business Act 2013, and Bank Negara also pass all the Sharia guidelines to develop the products for develop. So in other banks, if you want to introduce what they call new products, they need to comply all the Madya Shariah, Sharia parameters, Sharia guidelines issued by Central Bank of Malaysia. This is because it is to ensure the certainty of the Sharia compliance as far as product development is concerned. Okay, can we move to the next slide? And then as far as this one, dispute resolution, because in essence, it's basically is a duty of the king to protect the property right of the citizens. So we need to respect the ownership right of the peoples. All right, this is basically relationship between man and man. So the king is the duty of the king to establish the court as to safeguard the interests of the public as a whole, as far as civil transaction is concerned, as far as Sharia is concerned, and whatnot. So in order to what I call resolve all the grievances between the parties, between the general public in Malaysia and with the bank sectors, Bank Negara Malaysia under IFSA establish what we call Embarrassment for Financial Services. So if you have any problem, you're not satisfied with the banking problems, banking products and whatnot, the way the bank treat you and whatnot, you have a strong basis so that you can launch a report to this channel, Embarrassment for Financial Services. Then we can move to the next slide. So as far as dispute resolution is concerned, we have the court system, civil court system in Malaysia, and we have also the Sharia court system to cater uh, Islamic banking system in Malaysia. Previously, as I mentioned to you, Sharia law used to be the law of the land, and Sharia court is higher level. And but after the how the British coming in through what they call Pangko Treaty, through the agreement where all the Malay state and Malay rulers need to act upon all the advices by residential general of the British. So they need to follow. So how they conquer our land and introduce the law is talking about the colony. When there is a disputes between British and British, they need to follow the British law. But if the British, if the the dispute rose in Muslim land, so they need to follow the Sharia law and whatnot. And so long that they are enhanced, they call their land territory. So when the dispute occurred in their jurisdiction, their territory, so Muslim need to follow the British law. So that's how they negate the power of the Sharia court in Malaysia. And then they introduced federal constitutions, and they caters the matters at the federal level and the state level, and now all the Sharia courts pertaining about Muslim family matters, about the divorce, talking about maintenance, child custodies, and whatnot. So, but as far as Islamic banking is concerned, since we're talking about banking here, this is under the federal level, so that if is there any dispute, is not to be resolved at the civil court. In other words, the civil court procedures will be applied, the civil court interpretations will be applied, and whatnot. So, can we proceed to the next slide? Can we proceed to the next slide? Mohd Shariah. Right. This is the structure of the Malaysian Civil Court, Civil Justice System. So the lowest court we have, we call it Magistrate Court. Magistrate Court, we have Civil and Criminals Division. The Session Court as well, we have Civil and Criminal. And then as far as Islamic banking disputes is concerned, we have what they call high court level, we have specific court. It's not a Sharia court, but a civil court, high court, we call it Muamalat Division. So we don't have the specific Muamalat court as yet, as compared to other jurisdiction like in Sudan and whatnot, to hear the Islamic banking cases. And in fact, some of the cases has been heard at the session court level. Most of the cases are pertaining about the default judgment where the customer failed to pay to the bank. So very small numbers of the case that tested on the validity of the Sharia contract entered into between the bank and the customer. Some of the case are talking about the constitutionality aspect of it, you know. So this is if the parties is not happy at the high court level, Muamalat court here. First we have magistrate court, session court, and then you straight away file the case at the high court level, Muamalat. If you're not happy, then you can go to the appeal court level, and then the highest court in Malaysia is federal court. So, but then, if there is some disputes, so for example, we're talking about the what they call the notion of hibah, the notion of giving hibah through takaful, because hibah rukbah, conditional hibah is accepted for takaful businesses. So you give right away the property, but it's always been challenged. Yes, you give hibah based on the ifsal, but if the party is not that happy, always the legal has can challenge in terms of the validity of the hibah itself at the Sharia court. It's happened, in Terengganu recently, where the parties are not happy, they challenge the validity of the hibah because they say the compensation should be distributed according to the principle of faraid, the principle of Islamic law of inheritance. So you see, I just want to see the development of the case. So there is a conflict of the jurisdiction between the act and how they resolve the matters. So I hope we can resolve the matters amicably. All right, can we proceed to the next slide? So as I mentioned to you, as far as the Islamic banking Sharia matters is concerned, the absolute authority in Malaysia is what we call Sharia Advisory Councils, embodied by all the learned scholars, Sharia scholars, in terms of the fiqh muamalat. So this is the highest authority in Malaysia. So this body, the one that said what calls pass the Sharia resolutions, approved the what call Madya Shariah. So whatever what they call Sharia opinions, a Sharia resolution passed by Sharia Advisory Council shall bind the court and arbitrator. But when it comes to the court, basically this is the duty of the Sharia Advisory Council is basically to ascertain the validity of the Sharia point of view. But still, the ultimate issue rule is up to the court, the judge. The judge still have the independence to give his own judgment. So if the court can form its own opinions based on the certain facts and whatnot, it's not necessary that Sharia Advisory Council be called before the court. But the question here is that when the Sharia Advisory Council be called before the court, the duty of the Sharia Advisory Council is basically to ascertain the Sharia principles, Sharia rules, so that the court can form its opinion and give judgment for that matter. So the question on determinant is basically lies in the court. And then we see in the later on some of the court cases pertaining to the reference to the Sharia advisory councils. Can we pass this? So you see the case of the Bank of Kerjasama Malaysia Badminton. So the court says, it is compulsory. So more or less it's compulsory to refer to Sharia advisory councils because they don't have the expertise in the muamalat matters. So when it comes into fiqh muamalat matters, Islamic banking matters, they're not to resolve certain issues and whatnot. So it needed to make a reference to Sharia Advisory Council of Bank Negara Malaysia. So in the case of Muhammad alias Ibrahim, RHB Bank 2011, so the question before the court is that, in fact, Sharia Advisory Council been called before the court to give their own opinion whether the collateral capital charge before the bank is in line with the principle of rahnu. So before the bank go to forfeiture and whatnot, as far as rahnu is concerned, you need to get the consent, right? You need to get the consent before you go for another foreclosure and whatnot. So the court in this case, so all the Sharia council being called to testify their opinion about the matters, whether is capital charge, conventional charge, or is it a rahnu. So the court in this case decided is that from very beginning, at the very first place, the parties never intended when they file the charge and whatnot, the charge, registered the charge. This is not the intention of party. The party never intended to make that particular collateral charge as a rahnu. So in other words, the principle of rahnu is not being applied as far as the capital charge is concerned. And then recently at the federal court level, this is highest court in Malaysia, decided the case of JRI resources and whatnot in terms of the validity of the section 56 and 57 of the Central Bank Act. That's now, as I mentioned to you, whether they negate away the function of the courts. And in this case, the court still says the ultimate issue rule is the court to decide the matters. So the duty of Sharia Advisory Council is basically to ascertain the validity, whether it's contract is Sharia compliance and whatnot. So as far as quick finance house is concerned, the matters is that who should bear the cost as far as the major maintenance is concerned. So as far as Madya Syar'i passed by Bank Negara Malaysia, as I mentioned to you just now, they say the parties, if they agreed, so the customer to the bank can bear all those costs. So in other words, they look into the intention of the parties for that matter. So that is basically a few cases that I share with you. So we have series of cases when we also have a series of international cases and whatnot that I can share you later on. So for the sake of this lecture, I just share these three cases. That's the reference of the Sharia Advisory Council is highly recommended. This is a must if the court cannot form its own opinion based on certain Sharia issues. And in fact, Tun Hamid, a former chief judge in Malaysia, is mentioned that very clear in the case of Latifah Madzin. If the civil court is not certain and on the Sharia issues, certain Sharia issues, in the case of Latifah Madzin at federal court level, it's the duty of the civil court to refer to the Sharia court and otherwise. So we set a good precedence. And so that's the way should be the attitude of the court as far as Islamic banking and finance dispute resolution is concerned. But as I mentioned to you, this from the theoretical perspective, it's the duty of the king to protect the ownership right of the people. So we need to respect the property right of the people. All right. So it's about the relationship between man and man. So the court, be it Sharia court or civil court, they need to ensure the principles of justice and fairness come to play. Is usually, in lines with the principle of maqasid Sharia. That's the way it should be. So that is basically the spirit, the desire that, the memento that we should have. And can we proceed to the next slide? Then last year, Asian International Arbitration Center. This is arbitration center in Malaysia, catering for Asian and international dispute and whatnot. Passed what they call arbitration rules. Arbitration rules 2021 on the first September, 1st November, I'm not sure, right? 1st November 2021. So you're talking about the Sharia aspect of it as well, because in that particular rules, they're talking about who's basically Sharia councils, who can be appointed Sharia council, who's basically the Sharia expert. So what is basically the duty of the Sharia expert? The role that can play as far as the what I call the dispute resolution is concerned. Whether the parties' autonomy, because the notion of the arbitration is that both parties need to agree to resort to arbitrations, right? So if one party refuses to resort to arbitration, we cannot go to the arbitrations. And we need to respect party autonomy in the sense that we have two parties in dispute. One party can bring his own Sharia advisory councils, and the other party need to bring his own Sharia advisory council as well. So we need to respect parties' autonomy. But the party also can choose all the appointment of the Sharia expert, as listed in the arbitration rules. All right, and the bottom line is that the arbitrator will decide the case based on the all the evidence, all the matters that bring before him. So, so that's basically the aspect of the Sharia aspect, more or less, as far as arbitration rules is concerned. So in Malaysia, we see the legal documentation, most of the party does not make the reference to arbitration center. Arbitration is a compulsory as yet. So they only refers if it matters is rising between the parties, they will refer to English law. They should refer to the Arbitration Act, or it should refer to the what they call IFSA, whether it should be resolved at the Muamalat Court, High Court Muamalat Division and whatnot. So I tend to believe that it's highly recommended to the parties to resort to the arbitration proceeding first, so that you can resolve the matters amicably, And of course, they got the Sharia experts in Panama, Sharia experts, Sharia councils, and the matters should, be heard by arbitrator. And of course, the notion of parties autonomy still being protected, being protected. So we can, Namshi, type. This is, let me recap whatever that I have shared just now. We're talking about the framework, the economy framework, and how the real economy framework has been decaded, because it's mobilization of resources. Allah Subhanahu wa Taala mobilized all the resources, because you see, in Malaysia, we have the climate, Kalistiwa and whatnot. We have plenty of resources. In Europe, the people eat, floors and whatnot. In Egypt, we got a lot of tamal and petrol. These are all resources, the sources of income to the countries. So mobilization of resources. And then, because coming to theory of the finance, they're talking about the what they call asset allocation, be it equity, or be it a debt base. Debt base basically triggers with notion of interest. And then because of the World War and whatnot, we have problems. The medium where you don't have what the cost society is not equal value and whatnot. In barter trade and the like, people create fiat money to replace the gold and silver. All right. So this one been interacted in the banking system. What is basically the duty of the bank is basically taking deposit and lend to the others. In other words, it's money borrowing and lending with interest. But the question is, the Islamic banking working under the framework of conventional banking, and who's basically dictate the entire operation of the conventional banking, as I mentioned to you, all the international regulators, like what we call World Bank, IMF, International Monetary Fund, Basel committees. We need to comply their requirements. But the next question is, what is the role of the World Islamic Bank? The role of OECD countries? Whereas Allah Subhanahu wa Taala mentions the trade should be traded among from the rich country to the poor country, from the rich and the poor. So just imagine, so if I circulate the money between, I give you 1 ringgit, you are rich people, why give you $1 to rich people and give $1 to the poor people? Of course, the poor people will appreciate that particular $1. If you give $1 to the rich is not, no use about the $1. Why you give me $1? It's no value to me. So what the big deal? $1, is a peanut to that set to some extent. So if you give the poor, so if the poor come to you and begging for you, is forbid for you wala tanharhum. So because that's why in Islam is very good. If we're talking about Islamic financial inclusion, about social justice, by the notion of the zakat, by the notion of waqaf. Waqaf, the notion is that zakat is basically to provide the wealth. Zakat, the waqaf is basically what they call to get closer to Allah Subhanahu wa Taala. And we have the principle of tabarruk, sadaqah, hibah, and waqaf, kaza kaza. Then can we move? So as far as Malaysian context is concerned, we have been engulfed with the British colonization. As far as framework is concerned, legal framework is concerned, we have running two legal systems, Sharia legal system as well as conventional legal system. But as far as constitution is concerned, fiqh muamalat is concerned, Islamic banking is concerned, is filed under the federal level. So all the matters will be heard at the civil court, at the civil court. And it's nothing to do with Sharia court. But of course, there is a movement, as I mentioned to you just now, but in terms of the validity of hibah and the challenge about the faraid, about the hibah itself, it's happened to the Sharia court in Terengganu recently. So, as far as Islamic banking is concerned, we have various Islamic finance is concerned, we have so many regulators. We're talking about Islamic finance. But Islamic banking is concerned and takaful, we have specific act, Islamic Financial Services Act, that to regulate the Islamic banking and takaful business in Malaysia under the umbrella of Central Bank of Malaysia, Bank Negara Malaysia. But as far as capital market and services and whatnot, we have what are called securities commissions. And then we have Bursa Malaysia. And then we have what called Labuan and whatnot. These are the regulators, Sharia regulators that regulates the contemporary Islamic finance in Malaysia. So in a nutshell, in Malaysia, the industry is heavily regulated. We have what we call a Sharia advisory councils, pass all the Sharia resolutions, Madya Shariah, as to ensure the certainty, the robust development, the product issuance are basically Sharia compliance. So that's what I can conclude our sharing session this morning. So, جزيل الشكر على حسن استماعكم. بارك الله فيك. أي سؤال؟
Okay, thank you very much, Prof, for sharing this excellent presentation and for discussing some cases, especially focusing in Malaysian cases. And I think our participants have benefited from your lecture session, from this very, very important for contemporary cases and issues that we are facing in almost all Muslim countries that we are practicing Islamic banking and Islamic finance. So I think that's very nice of you to have this sharing moment with us, and we thank you very much, Prof. So now I think we just open for question and answers or any additional points, any additional remarks from the participants. So I would like to request either to write in the question box or to raise your hand so that we can switch on microphone for you. Prof, there is a question from Mr. Saeed Masoud. Dr. Assalamu alaikum. Question is, which year the SSC for Islamic banking established in Malaysia? Also, is it before or after Islamic banking started?
Assalamualaikum warahmatullahi wabarakatuh. It's a very good question. We start with the committee. Committee. We start the committee way back in, before 1981. We have the specific committee, specific committee before we launched the Islamic banking. So we have specific book and reference, the history development of Islamic banking issued by ISRA. Very, very interesting books. We're talking about the history, the development, what we are doing, what are the achievements, what are the challenges that we face, in terms of establishing of the Sharia committee, the Sharia advisory councils. So we start with the committee before the establishment of the Islamic bank itself. And then we start with Islamic bank way back in 1980. And then 93 Bank Muamalat Malaysia. And then we start progressing with what we call window banking, Islamic window banking. And now, Alhamdulillah, we have specific entity. We have Maybank, we have Maybank Islamic, we have CIMB Islamic, and of course, they got some what we call the segregation of the fund between conventional and Islamic. Alhamdulillah, it's a good movement. Tatawur yani ijabi. Alhamdulillah. A very long journey. Alhamdulillah. Tatawur yani ijabi.
I think the answer is clear. Thank you, Prof. Then I switch on microphone for Sister Amina Sadiq. Yes, please, Sister Amina, please. Sister Amina Sadiq, please welcome. You may share with us. I switch on microphone already for you. Okay, let's move to second question. Okay, what is the meaning of Ambudisman mentioned in the slide? Is it the long term or not? Yes, Prof.
Embarrassment, embarrassment. This is embarrassment. It's what they call, those days we have a mediation bureau. Embarrassment is like count for Hisbah. If you get any problem, then you lodge a report. Embarrassment. So what they call the regulator at the embarrassment, we try to resolve the matters amicably between the bank. We see what the issues and the concern is, it pertaining the product itself, how's the bank treat you, things like that. And in fact, you can Google, you download our act, Islamic Financial Services Act 2013 in Malaysia. So in that statute, we call the act, they have specifically mentioned about embarrassment. Very interesting. And in fact, the practice of embarrassment from my studies also, it been practiced in other countries like in Pakistan as well as in Sudan. You know, and in fact, in Pakistan, we have what we call the notion of public interest litigation and their constitution. So if you're not happy, then the constitution recognize your right. So you can loud and of course with the proper channel and whatnot. So that is basically one body to resolve what we call the grievances between the bank and the customers and the bank. No, Jazakallah khair. Barakallah fiik.
شكرا أستاذ جزاكم الله خير. Brother Jasim, كيف ممكن التواصل مباشر معكم دكتور? Okay, at the second last slide, you may get the contact details of professor there. So if you download,
أنا أستاذ مشارك في جامعة إسلامية جامعة أوتارا بماليزيا بكلية حقوق. يعني هناك سلايدات في آخر الهلة، أنت يعني هناك يعني كل شيء يعني رقم اتصال كيف أتصل معي يعني بالهاتف أو بالإدارة. هناك إيميل أيضا. يعني الباب مفتوح لكم في أي ساعة في أي وقت، أنا موجود يعني. بارك الله فيك.
There is another question. Based on your experience, what is the biggest hurdle in making Islamic banking the main system in Malaysia, taking into account the existing dual system?
Well, you're talking about this one, this very long journey. And of course, we have what we call mind settings, the direction. And of course, we have very strong political will. The main hurdle is that about the education, the awareness. This is basically the key. But in Malaysia, we think education is a must. That's why Central Bank of Malaysia, they have what they call the NCF University, that specifically dedicated for Islamic banking and businesses. And then we have ISRA, يعني مركز لبحوث شيء يتعلق بمصارف إسلامية، يعني مركز خاص يعني لإسرا تحت إشراف بنك مركزي في ماليزيا. This is very important because about the education and the awareness as well as the mindsetting. And of course, we تطور يعني إيجابي. The main hurdle is that whether the general public, they really want to subscribe to يعني منتجات الإسلامي, product Islamic banking business. The main setting, this one is halal, this is haram, whether the general public want the products. So if majority of population in Malaysia, عدد أغلب السكان في ماليزيا يعني مسلمون. لكن لهم يعني يعتمدوا على منتجات الإسلامية أو يعني منتجات يعني مشترك بها يعني من بنك التقليدي. هذه يعني مشكلة من حيث المستهلك، ليس من حيث يعني البنك.
Shukran Ustaz, Barakallahu Feek. So is there any other question? Otherwise, we will conclude the session if there is no more questions or comment from the participants. So on behalf of Islamic Economics Association, we would like to thank all participants who joined us in this session and also in every session, English session, Arabic programs. In every day, we usually have programs under this umbrella, under this Shariah faculty of Kuwait University. So we thank you very much for joining us, for your participation. And our special thanks to Associate Professor Dr. Muhammad Zakhiri for your valuable time and for sharing your experience and your ideas. So we thank you very much, and may Allah bless you, Prof. So we hope to see
thank you very much, everyone.
Get you again in other upcoming sessions, inshallah. So yeah, please, your concluding remarks, Prof.
Syukran jazilan ala husni istima'ikum. Thank you very much on your cooperation, your participation. And of course, hazi mudahalah jayidah wa fursah zahabiyah min jami'atikum jami'ah Kuwait wa kazalika yani Islamic Economic Society in your institution. And I'm more than happy to assist in my level best, whatever is it. And of course, to establish Islamic banking within conventional framework is a bit challenging. It's a very long journey. And tajarub في ماليزيا يعني تجارب جيدة. يعني يمكن نتعاون ونشارك معا كيف يعني نطبق how to establish Islamic banking in Kuwait based on what we have learned in Malaysia, something you can learn from Malaysia. So syukran jazilan ala husni istima'ikum, barakallahu fikum hatta natasil mustaqbal, ma'asalamah. Syukran jazilan di mudir jalsah Dr. Muhyiddin. Alhamdulillah, barakallahu fik jami'an. Assalamualaikum warahmatullahi wabarakatuh.
Inshallah, see you soon again in other sessions, inshallah.
Barakallahu fik.
Conclude today's session here. Subhanakallahumma bihamdik. Ashhadu an la ilaha illa ant astaghfiruka wa atubu ilayk. Assalamu alaikum wa rahmatullahi wa barakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.